students coordinators, dear Shivam Tiwari, Saurabh Guha, and moderator and anchor of the day, my dear Shruti Singh. Dear faculty members and students, I, Dr. N.K. Bahel, Professor of Law at JIMS School of Law, Greater Noida, District Gautam Buddha Nagar, UP, on behalf of JIMS family and on my own behalf, heartily welcome Ms. Kanakprabha Jethani, ma'am, to JIMS School of Law. Jethani ma'am, our guest speaker of the day is from Vinod Kothari Consultant Private Limited, and she is a guiding force for all the members of her group and associates. It's my privilege to welcome you, ma'am, and we are really delighted to welcome you, ma'am, here. Dear participants, Jethani ma'am is an expert in the field of marketing structure and is dedicated to provide access to justice to the masses. Congratulations to you, ma'am, from JIMS family. At the same time, we are happy to know that Jethani ma'am has a keen interest in academics, and she has contributed various articles which have been published in various journals and magazines. We once again welcome you, ma'am, to JIMS School of Law, Greater Noida. And ma'am will invite you to our campus again once this pandemic of COVID-19 is over. And we thank you so much for accepting our invitation, ma'am. Dear students, today's topic, role of Competition Commission of India towards various market structures, is a very interesting subject in today's contemporary world, and you will be greatly benefited by today's deliberations. Dear students, today you will definitely learn the niceties and intricacies of marketing structure and role of Competition Commission India in its development. Jethani ma'am, you are once again welcome to the family of JIMS. Over to moderator Shruti Singh, please.
Thank you, sir, for your kind words. Now I would like to introduce our ma'am. Kanakprabha Jethani ma'am is a commerce graduate and associated member of Institute Company Secretaries of India. She secured all India ranks consecutively throughout the stages of company secretary examination. She has over 3 years of experience in the field of banking and non-banking financial regulations, various types of financing products, unconventional modes of financing, drafting legal documentaries, agreements, and company secretary matters, and anti-money laundering, etc. She regularly authors several articles on the vast range of topics on esteemed blogs such as Taxman, Indian Corporate Law, and Money Life. Currently, she is a manager with the Vinod Kothari Consultancy Private Limited. Now I would like ma'am to take over the stage.
Thank you so much, Shruti, for the introduction. My heartfelt gratitude to Bahel sir and Dr. Shishma for inviting me here today. And I would like to now introduce you, since I have been already introduced, I'll now introduce you to how the session is going to be done today. See, the session is about Competition Commission of India. Now, this is something that we see in our everyday life, which is why I would want this session to be communicative and interactive. I'll request all the students to participate as much as they can and give their suggestions, comment, or ask their queries if there is any. So what we'll do is we'll divide this session into 2 parts. Firstly, we'll understand the basics of the competition law. Thereafter, we'll take a 5 minutes break in which the students can come up with their queries and everything. And then we'll move on to the role of CCI and how CCI works. I'll just share my screen now. If someone can confirm if my screen is visible.
Yes, ma'am, it's visible.
Okay. So the topic of today is Competition Commission of India. Before we move on to understanding what Competition Commission of India is and what it does, let us first understand what is competition And why is there a need for a law with respect to competition? The competition, as we all know in general parlance, means anything wherein two people, two parties, or two groups compete with each other to prove that one of them is better than the other. Similarly, when this competition comes to commercial markets, such as the sellers of the products or service providers competing to prove one of them is better than the other, it is called competition in the perspective of competition laws in India. Now, why is there a need for competition law? The reason behind this is, as we all know, competition is always good. Competition will always promote you to do better. But during the competition, there can be several unfair practices as well, which is why there is a need for a law to regulate the manner in which the competition is taking place. So here I introduce you to one more act for the to-be lawyers of the country, the Competition Act 2002. The Competition Act 2002 regulates the competition and the related practices in India. Moving on. So by the end of this session, what we'll take from here is understanding the concept of competition and its importance, the construct of competition law in India, its applicability, scope, and purpose, the kind of anti-competitive practices that can take place, and lastly, the role of Competition Commission of India in regulating competition in several market structures. So let us start with what competition means in the ambit of competition laws. World Bank defines competition as a situation in the market in which sellers independently strive for buyers' patronage. That means the sellers strive to have more buyers or more market shares, or more market share, or let's say profit, sales, etc. Basically, the want here for the seller is to expand its outreach and have more buyers, do more sales, earn more profits. Now, promotion is not necessarily always healthy. However, it is very necessary to have competition so as to ensure growth of an economy. Let us think for a while, if there is no competition in market. Let's think there is only one seller for each product that is available in the market. What will happen in that case? If there's only one seller, that one seller will be able to put any restrictive condition, charge whatever price they want. And this may not be in line with buyers. Yes, Anjali is saying monopoly, correct? Yeah. So this may not be in line with what buyers want, or this may be unfair to the buyers, which is why it is very important to have some degree of competition in the market. Now that we have understood the meaning of competition, let us now move on to understanding the basic construct of competition law in India. Competition Act was introduced in 2002. Before that, there was another act to regulate competition, that was MRTP Act, Monopolies and Restrictive Trade Practices Act 1969. Now, the basic construct of MRTP Act was that it did not allow having any monopoly, which means that there could not have been any monopoly, however, which was not even at that time practical. Another thing that the Act prohibited was having dominance. Dominance means having a position of strength in the market. Now, when liberalization took place in 1992, the Indian economy was open for foreign participants as well, and there was a need to promote Indian economy. Now, in such a growing economy, at such a transition stage of the economy, had we restricted having dominance, we would not have been able to see people like Tatas and Birlas. Now, it is very important, at that time it became very important to have bigger firms as well as allow some monopoly to open the Indian markets to several kinds of products and services, which is why the MRTP Act was abolished and the Competition Act 2002 was introduced. The basic construct of the Competition Act was not at all to restrict anything. The nature of the act is very open and accepting. The act does not prohibit monopolies. It does not even prohibit dominance. But what it prohibits is abuse of that dominant position. So there is a difference here. While MRTP Act did not allow you to have any dominant position, it will restrict you once you have a sufficient amount of market share. The Competition Act promotes you to have bigger market share, have a position of strength, but does not allow you to abuse that. So this was the basic difference between the erstwhile Act and the Competition Act that is in parlance now. Moving on to understanding the objective of the Act. Now, as we have already seen that the nature of this Act is very open and accepting, the first and foremost thing that this Act ensured was to promote and sustain competition in the markets, along with preventing practices that are anti-competitive or will have an adverse effect on the market. These two were the basic constructs on which the Competition Act is based. Along with this, the Competition Act does not want to curb your freedom of trade. It will always ensure that you are free to do trade in whatever manner you want, as long as it is not in contradiction to the interest of the customers. Now, the Competition Commission of India is also is a body which is incorporated under the powers given by Competition Act. The intention of the CCI is again in line with the objective of the Competition Act, which is to establish a robust competitive market, to keep reviewing and overlooking the practices that are going on in the market, and wherever there is any activity which is going to have an appreciable adverse effect on the market, to curb those activities, and to also ensure that people are aware about the competitive practices, people are aware about their rights, and advocating competition in general. This is the basic objective of the Competition Act and the CCI. Now, if I broadly look at how Competition Act looks, the Act first of all has certain definitions. Then it goes on to explaining what are anti-competitive practices, which can be divided into three types. One is anti-competitive agreements. Second is abuse of dominance. And third is entering into combinations which are likely to affect competition in the market. Now, the Act also provides for establishment of a CCI, which has already been established, and the powers that the CCI has, the duties of the CCI, the role that the CCI is going to play, the manner of investigation of anti-competitive trade practices, how CCI will carry it on, and what will be the outcome of it. So this is the basic construct of the Competition Act. Now, before I move on to dealing more into Competition Act, let us understand what kind of market structures can exist in today's market. Now, there are two extremes to the market structures. One is perfect competition and another one is monopoly. Between those, there can be several other structures as well. Let us start understanding what is monopoly. As you can see from the picture also, in monopoly, there is only one seller in a relevant market. Now, I've been using several terms like relevant market, appreciable adverse effect on competition, what things. If I have to explain relevant market to you, which we'll obviously deal in detail in the upcoming slides, but just to give you an introduction, a relevant market is not a specific marketplace or a mall or a shop, but any area. This area can be a geographical area or a product-based market. Now, how do I determine what is relevant market for my product? It depends on the nature of the product, its availability, the ease of access of the product. Let us take an example to understand this better. Let's say there is one economy where there is unavailability of petrol. There's no petrol in that area and people do not have access to vehicles, etc. If this is one single country that does not have the availability of petrol because of XYZ reasons, that entire country is a relevant geographical market for the product named petrol. Similarly, if one of the cities in that country is having access to petrol, however, others don't, the entire country except that city will be the relevant geographical market for that particular product. And so the nature of the market depends, or the extent of your relevant market depends on the homogeneity of the conditions in which the market is existing. Now that we have understood what a relevant market means or how it is determined, what a relevant market is, let us understand what is monopoly. A monopoly is a market wherein there is only one seller of a product. Now, obviously, since there is only one seller, there may be several reasons behind it. One of the reasons may be that there is an entry or exit barrier in the market. That means there are restrictions on what participants can enter into market, or the manner or the entry conditions are so stringent that other sellers are not able to capture. Another reason can be that the product is a very exclusive product. By exclusivity, I mean that products of similar nature are not being able, other sellers are not being able to provide the products of similar nature. So these can be some of the reasons why monopolies are created. Now, some of the features of monopoly market. Let us look at a monopoly with an example. Monopolies can be, let's say, for example, in certain areas, electricity provision or the services of providing electricity are only open to the government. There are no private players in the market. Now, here there is a monopoly by the government. Now, if I look at the features one by one, there are entry and exit barriers because it is only one single party, that is the government, that is allowed to do. So there are restrictions by way of regulatory controls. Moving on, there are also restriction on information. How? If there is only one entity, that is the government providing electricity services, there is no free flow of information since there are no competitors and the customers have to rely on what is being provided by the government. There are barriers on free flow of the information. Now, in this case, since there is only one seller, the seller will also be able to control the prices or regulate them in its favor. In these kinds of markets, the importance is on the seller and not the customer. The customer is the taker of the price and the seller is the maker of the price. So this is how a monopoly works. Now, monopoly can be created in two ways. It can either be a natural monopoly or it can be a legal monopoly. If I talk about natural monopoly can come in several ways. Let's say, for example, look at the Pashmina providers in Kashmir. Currently, we can see so many Pashmina shawl providers in Kashmir, but however, if you go a few years back, there was one single family which used to produce this. So they had this naturally, and this product was exclusive. Similarly, a legal monopoly is created by having certain legal rights. Let's say if I have innovated a product and I get it patented. Now my patent is something that gives me the right to exclusively produce that product, which means other people cannot copy my technology and produce a similar product and offer it to the market. In this way, I can create a legal monopoly for myself so that I'm the only provider of the specific patented product or service in the market. So this was all about monopoly. Let us now go and understand what is oligopoly. Now, an oligopoly is a market wherein there are few sellers and many buyers. Let's say a handful of sellers that you can count on your fingers and lots of buyers. If I have to take an example of an oligopoly market in India, I can think of airline companies. As we are aware that the airline companies in India, there are very less number of airline companies that you can definitely count on your fingers. Now, why is that so? Some of the reasons are: one, the expenditure involved in starting an airline business, the maintenance of employees, pilots, aircrafts, everything. The aircraft maintenance is itself a very costly affair. And then there are several regulatory restrictions as well. So all of these factors come together to create an entry barrier for the new entrants in the market. In these kinds of markets, what usually happens is one seller is dependent on the other for several reasons. Let's say for sharing of information, sharing of new technologies. The manner in which one seller decides the price becomes a benchmark for how other sellers will decide their price. So there's a lot of interdependence between the sellers in the market. Now, because of this interdependence and interlinkage of how these sellers are going to behave or how these sellers are going to offer their products, the terms and conditions, the pricing, there is a rigidity on the price, which means that if one seller tries to reduce their price to meet the customer's needs, other sellers will pitch in and accordingly reduce their price. If one seller increases their price, the other sellers are also likely to do that. Now, in these kinds of market, the demand and supply of the product are not the only determinants of the pricing. Now, how do demand and supply help in determining the price of product? This is something we'll understand in the next 2 minutes. Let us for now understand the rest of the types of market. Before I come to monopolistic competition, let us understand what is perfect competition. So in a perfect competition market, there are large number of buyers and a large number of sellers. In these kinds of markets, the prices of the products are clearly driven by the demand and supply factors. How is this possible? Is because the product market is homogeneous. Let us, for example, take a very regular use product, let's say toothpaste. So toothpaste is something that is very homogeneous. Of course, there are several flavors, several types, and several uses of these toothpaste. But if we notice in today's market, each and every brand that produces toothpaste is trying to compete with the other, and they bring out several variants of these toothpaste matching the features of the toothpaste that is provided by their competitor, which is why there is a balanced homogeneity maintained in the market. Also, there are no such entry or exit barriers in these kinds of market. Now, a perfect competition market works on certain assumptions. The first assumption is that the customers have perfect knowledge of the products that are available in the market. This, however, may not be very practical, or this may not be practically possible. Similarly, the market also assumes that there are no overhead or transportation costs as such. Now, the reason behind this is that in case there are overhead cost or transportation cost, these costs will differ for each type of seller or each type of manufacturer, which will result into an imbalance in the pricing. However, assuming that there will be no overhead cost or transportation cost is impractical in today's scenario, which is why a perfect competition is a theoretical concept. What practically exists in the market is an imperfect competition, which has features of perfect competition, less the assumptions that we just discussed. Now, coming back to monopolistic competition. Now, monopolistic competition is a combination of the entire extremes of the market, that is monopoly and perfect competition. If you club these two, you will have monopolistic competition. Now, how does this work? One, that like a perfect competition, there are large number of buyers and large number of sellers. But like a monopolistic market, there is also exclusivity of the products. Now, how does exclusivity and a large number of sellers work together? So the exclusivity of the product here does not mean that the product itself is exclusive, but there are certain features of each and every product that are exclusive. Again, like a perfect competition, there are no entry barriers for sellers in this market. The prices here are driven by demand and supply, as well as the features of the product or the services that is being supplied. Now we have talked about this demand and supply affecting pricing of a product. Let us see how this works. So I'll show you a small graph here. Let us look at this. Let us look at this graph wherein x-axis indicates the quantity of the products and the y-axis indicates the price of the products. If I have to draw a demand graph here, when the prices are the extreme highest, the demand of in terms of quantity will be low. And as the price reduces, the demand will increase in terms of the quantity. So a demand graph in this case should look like this. Similarly, if I have to look at the supply graph, supply will be lowest when at lowest prices and it will increase as the prices increase, which is why a supply graph will look like this. Now, where these two graphs intersect is the price that the market accepts. This is how price determination takes place in case of a perfect competition, which is entirely driven by the demand and supply forces. Now, how does price change with change in demand or supply? Let's say the demand increases, and the supply remaining constant, what will happen is the price of the product increases along with the quantity that the customers want to purchase. If let's say at this level of demand, there is an increase in the supply, what will happen is the prices will tend to reduce along with increased quantity of supply. This is how the demand and supply factors come together to determine the pricing of a particular product. Now that we have understood the several market structures and how pricing takes place in each of them, let us move on to understanding what are the methods of undertaking anti-competitive trade practices. As I already discussed, there are three modes of doing anti-competitive trade practices. One of them is entering into anti-competitive agreements. The second way can be using your dominant position or using your dominance to your favor, that is abusing the dominant position. And third is entering into such combinations which are going to affect competition in the market. Now the CCI, or the Competition Commission of India, has a role in each one of these. How? Any of these anti-competitive trade practices, if they come into the eyes of the CCI, it is the CCI's duty to investigate, determine if there is an appreciable adverse effect on competition, and accordingly allow or disallow such practices. So this is basically the entire role or the entire objective of having CCI in place. Now, before we move on to understanding what are anti-competitive agreements, there are certain terms that we have discussed by now. One was relevant markets. Although for an example, we try to understand how a relevant market is determined, there are several other factors also that come into play when you're determining a relevant market. Now, this again is the duty of the CCI to determine if a market is a relevant market or not. Similarly, in each type of agreement that is taking place in the market, it is the duty of the CCI to determine whether the same is anti-competitive and whether the same has an appreciable adverse effect on competition. Now, appreciable adverse effect on competition means such impact on competition that works negatively for the market and the customers. And the extent of such negative impact is so that it can affect the pricing or the manner in which the customers perceive that product or service, or the manner in which it is offered to the market. Now let us see what are anti-competitive agreements. Anti-competitive agreement can be any agreement which is going to have this appreciable adverse effect or so-called negative impact on the market. Now, anti-competitive trade agreements can be undertaken in two ways, either vertically or horizontally. When I say horizontally, what I mean is these agreements will be at the same level of production or the supply chain. If I'm a manufacturer of a service or a product, if I enter into an agreement with the manufacturer of a similar product, I'm entering into a horizontal agreement. However, if I enter into an agreement with, let's say, the distributor of my product or the provider of the raw materials of my product, these agreements are vertical agreements. Now, there can be several ways in which these agreements become anti-competitive. If I take an example for vertical agreements, I can have an exclusive supply agreement or an exclusive distribution agreement. In an exclusive supply agreement, what happens is I'll enter into an agreement with my raw materials provider that he will supply the specified quantity and the quality of raw material to only me. What will happen is that specific quantity of raw material only comes to me and not to other sellers in the market, which results into creation of a kind of monopoly or a kind of restriction on other sellers or other manufacturers having access to similar kinds of raw materials. This in turn will impact the quality of the final product that is produced. Now, definitely a product with better quality will be more accepted by the customers. Similarly, there may be exclusive distribution agreements as well, wherein I can enter into an arrangement with a specific distributor in a specific area that specific distributor is going to offer my products only. Now, these exclusive supply agreement and exclusive distribution agreements are very common in everyday trade parlance. Not all of them are anti-competitive. What we need to look at while determining whether they are anti-competitive or not is their impact on the market. Do they impact availability of other similar services in the market or not? Or ease of the customers, whether they are unfair to the customers. All these factors will have to be looked into before determining whether these agreements are anti-competitive. Similarly, let us take an example for horizontal agreements as well. Let's say I enter into an agreement with my competitors to reduce the supply or control the supply of a product. Now, as we also recently saw in the demand and supply graph, if the supply of a product is reduced, the prices of that product tend to increase. And so if someone is entering into such contracts, these are anti-competitive. An example of limiting a supply or controlling the production can be seen in everyday life. The most common example will be your vegetable vendors. There are so many times wherein you will see the prices of onions or potatoes rise substantially over a period of, let's say, a month or two, and then they drop down immediately. Now, this many times happens because of hoarding, which is a manner of restriction of the supply. Let us move on to understanding what is dominant position in the market. This is the second type of anti-competitive practices. As I already told, having dominance itself is not wrong. Abusing that dominance is wrong. So first of all, let us understand what is a dominant position. A dominant position is a position of strength that a particular seller enjoys in a relevant market. Now, how is this a position of strength? This may be because this particular seller is able to operate independently of its competitors, the prices offered by its competitors, or the practices or the offers provided by the competitors do not impact this particular person or this particular seller. And in case this particular seller goes on to reduce its prices or offer certain deals on its product, the other competitors in the market are driven to follow that. If I have to look for an example of a dominant position, we can say Google. Google has a dominant position in the search engines market. If I have to think about the search engines, the first thing that comes to mind is Google, followed by several other search engines. Now, let's say XYZ search engines make their services chargeable, and Google will have no effect on that because Google can still operate independently. However, if Google comes and tries to make services chargeable, it may look like a silver lining for the other service providers who are still providing it for free. However, if Google is taking such a decision, other market players will be tempted to think of the reason behind it. There may be increase in costs, or there may be other relevant factors that are impacting Google to take such a decision, which will drive how the other competitors in the market behave. Now, having a dominant position is relevant in a specific market or a relevant market, as we discussed. I think we all understand what a relevant market is. It is important to note here that you and I are not in a position to determine what a relevant market for a product is. This is the duty of CCI, which they undertake based on several factors. Now that we have understood what a dominant position is, let us understand what abuse of dominance is. Now, abuse of dominance would mean taking any kind of action which is going to affect other players in the market as well as the customers negatively. For example, denying market access to certain customers. For example, using relevant or the dominant position in one relevant market to enter others. Let's say, for example, Google, as I just said, has a dominant position in the search engines market. If Google now introduces a phone, people will be tempted to look at the product to see how it performs, and at least for the initial period, the people will be tempted to buy that. So Google's dominant position in one market helps it enter other markets. Now, entering other markets, as long as the product offered by Google is competitive, is not wrong. However, if such position is being abused and the customers are being unfairly treated or being provided with unfair terms and conditions, that becomes an abuse. Let us look at some abuse of dominant positions. Since I'm a financial sector expert, I'll give you an example from a financial institution's perspective. If a financial institution is having a dominant position in a relevant market, it is very likely that this financial institution is a huge sized firm or a huge sized company. Now, behind its huge size, there may be several things. It may be years of seasoning. It may be the good management of the company. But the most important factor in this is the cost of funds at which this financial institution avails. It will obviously be lower than other competitors in the market, which is why this financial institution is able to provide products to the market and expand its market share. Now, since this institution has cost of funds available at cheaper rates, it can offer the loan products to the market at cheaper rate compared to the competitors. What happens due to this is the customers will be driven to buy the loan products of this specific financial institution, and the other financial services provider who do not have access to cheap funds and who are not able to provide funds at such cheap rates will be driven out of the market. Similarly, what this firm can also do is bundle its unrelated services and force the customers to buy these. Let's say if I'm a loan provider and I can see that the customers are going to come to me for their loans, I can bundle my loan product with an insurance, which is compulsory. However, the IRDAI Act does not allow financial institutions to do this. That is the compulsory provision of insurance along with a loan product. But in case someone tries to do this, this is again an anti-competitive trade practice. Dr. Shishma has been telling me that there's less time left, so I'll try to move forward quickly. Now, the third type of anti-competitive practices can be entering into combinations which impact the competition in the market. Now, combinations can be in several ways. They can be in the manner of a merger or an amalgamation or acquisition of shares of one party by the another. Now, there are so many mergers taking place in the country. Are all of them regulated by the competition law? The answer is no. So not all combinations need to be regulated. However, there are certain thresholds. So the huge size combinations need to be regulated. If I have to look at the assets of the combined entity, let's say take for example a merger. So after merger, if the assets of the entity in India are more than 1,000 crores and the turnover exceeds 3,000 crores, those combinations need to be regulated. Now, there are several limits or benchmarks for each kind of combination. Moving on, what happens when you exceed this threshold? So once you exceed this threshold, what you need to do is you need to send a notice to the CCI within 30 days from the decision, from the date when this decision of the merger or amalgamation is taken. Once CCI receives the notice, the CCI will review the facts of the case and accordingly decide whether there is any prima facie appreciable adverse effect on competition. In case there is, the CCI will issue a show cause notice to the entities entering into the combination. The parties will have to respond within 30 days, after which the CCI may require a Director General to investigate into the procedures. This Director General is another party who is appointed under the Competition Act. And this party is usually given the responsibility of investigating the cases for CCI and carrying out all such activities that the CCI requires. So this DG will prepare a report of their investigation. Based on this report, the CCI will review the report and ask the relevant persons to provide requisite details if any are required. Once all of this is done, the CCI will invite public comments on or objections on the combination. And once public comments are received, CCI may call the combination parties for another round of maybe inquiry or asking additional information from them. After these parties provide the information, the CCI will give a final order. Now, the final order can be in several ways. One, if there is no appreciable adverse effect on competition, CCI will approve those combinations irrespective of the size. Second, if there is an adequate appreciable adverse effect on competition, the CCI may direct the parties to not take this combination into effect. The CCI may reject the combination and the parties will have to comply with that. The third way can be that there is an appreciable adverse effect on competition. However, by making certain changes, this can be tackled. So in these cases, what can be done is the CCI will propose certain modifications to the combination, and if the parties accept the same, they can move on with the combination based on the modifications proposed by the CCI. Now, is CCI the only authority? Can I not go against CCI if I'm aggrieved by the order of the CCI? So the answer is, in case any party is aggrieved by the order of the CCI, it can go for an appeal to the NCLAT, the National Companies Law Appellate Tribunal. So this was basically the role of the CCI, how CCI looks into the kinds of combinations or anti-competitive agreements and takes a decision on them. Along with this, the CCI's role broadly is also to educate the customers, to oversee the combinations taking place, to protect the interest of the customers, to inquire into any kinds of agreements that are taking place. Now, where does CCI get this information from? The CCI may first get the information through its own by looking into the agreements taking place or the practices taking place. Two, the customers or competitors are also open to inform these things to the CCI. Now, the CCI also has jurisdiction not only over the agreements that are taking place in India, but also the agreements that are taking place outside India, but will have an impact over the competition in the relevant markets in India. Now, the CCI's composition. So CCI basically consists of a chairman and 2 to 6 members. All of these are people having expertise in areas such as international trade, economics, business, commerce, finance, accountancy, with at least 15 years experience. Now, these people are recommended by a selection committee, which consists of Chief Justice of India, the Secretary to MCA, the Secretary to Ministry of Law and Justice, and certain experts. Now, currently, the head office of CCI in India is in New Delhi, and there are certain other offices, one of them being in Chennai. You can also look at who the current chairperson and who are the members of the CCI through its website. So this is maybe something that is a takeaway for you as well. Along with this, as we also discussed during our discussions, the CCI may appoint Director General, some Deputy Director Generals and Secretaries, which again are people with adequate experience in the relevant fields. And their role is to assist the CCI in conducting inquiries. With this, I would like to finish my session. I have put in some links for you to read about the most famous cases that have been reviewed or investigated by the CCI. Thank you so much.
Thank you, ma'am. Now I would like anybody to have any queries, questions related to it.
I think everyone has understood everything.
Oh, I have one question, Kanak. Ma'am, you just told us that the CCI, as in when the organizations or the companies are entering into the merger, or they are entering into the collaboration, then they need to give a notification to CCI, right?
Correct.
So, what if they don't give any notification to CCI? Means if they do not inform,
In that case,
then how the CCI will be getting the information about the same?
see, currently the regulatory infrastructure that is there in the country is that all the regulators are trying to streamline their databases. Let's say, for example, if I'm uploading something on the MCA, SEBI and RBI get notified about the same. So CCI is also trying to develop a similar infrastructure wherein they can get the data from the MCA or any other relevant source for that matter. Currently, what happens is if there is any merger that is such huge of a size that that goes beyond the specified thresholds, that is definitely going to be covered by the news or being known by the market participants. So if these people do not inform the CCI by themselves, the CCI can take an action and ask these people to specifically provide the information on the data that they receive from the market.
Okay.
I think
Thank
there's
you.
one more question on the chat.
Yes.
What are the possible cons of government monopoly? And so you must be noticing this is a very practical thing. What happens is in a government monopoly is even though the government is trying to provide us with the best possible services, there are so many cases where we see there is a lack or deficiency in the services, in the quality of the services. However, because the government has a monopoly and other private people are not having entry to this market, the customers usually learn to stay with it or they try to adjust with it. So this is one of the cons of the government monopoly. Another can be pricing. However, since it is government provided, governments usually keep the prices in control. However, the quality of services is something that if the private people are given entry will be better. Any more questions? There's one question. What was the reason due to which the CCI Act was amended in 2007? If you can give me what exact amendment was that, because I do not correctly recall it right now. That you can unmute and speak maybe. Okay, so I just checked. So the amendment that I could see was introduced was allowing NCLAT to take appeals against the orders of the CCI. This happened because there were certain big market players who were not satisfied with the orders of the CCI and they wanted to continue with their businesses, which is why they wanted to have an appellate authority. Okay, along with those, I think there was an introduction of mandatory notification for mergers. this, yes, as we discussed, was in case of mergers, usually what used to happen is people did not used to notify this to the CCI because they were of the opinion that this is an usual business decision. However, it was mandatorily notified that all these mergers need to be now notified to the CCI. I think we have no more questions now.
Yes, ma'am. Now I would like to call our coordinator, Shishma ma'am, for vote of thanks.
Thank you, Shruti, and thank you, Kanak ma'am. Thanks a lot for such an enlightening session for all the students and for all of us. Actually, although means as I'm a management faculty, so I was not aware about all these some legal aspects of the CCI, that how CCI is working, and it was actually enlightening session for me too. So first of all, I would like to thank our HOD ma'am who has, promoted us, and she has just pushed us to conduct these type of sessions. So I would like to thank our HOD ma'am. I would like to thank Kanak ma'am and my moderator Shruti. And I would like to thank Behel sir also, who has joined this session and who has blessed us with his wisdom words. And I thank all the participants who have attended this session, and they have listened it very carefully, and we had a very fruitful QA session also. Thanks a lot, everyone. I believe with this, I just want you all to please open up your camera so that we can have a group photograph.